Yes.
For a listing of this criminal petition, my lord, I am for the respondent. And 1 week time was sought earlier, my lord, by the petitioner on 17/5/2024. Any date, my lord? And they has taken the stand that authorized signatory is
14th.
responsible.
May I please,
14th.
14th.
may I please, Your Lordship, but for item number 1, my lord, that I have filed my affidavit in opposition, that may be called for, my lord. Item number 1.
Lord, I am praying for listing of a criminal revision petition which was listed on 26, my lord. For paucity of time, honorable court could not take up the matter.
9th.
Obliged.
May it please your lordship. Lordship, with the consent of the other side, I'd like to mention item number 23 of the daily list, your lordships. Your lordships, the difficulty is that we could not prepare the case properly today, your lordships. Just a day's accommodation if it is not inconvenient to your lordship.
Let the matter reach. It is a 2011 matter. Consider at that stage. Okay. Let the matter reach.
May I please your lordship? Lordship, I pray for listing of a criminal revision petition. The prayer was allowed for listing on 29 of July, lordship, but the matter was not listed on that day. And the difficulty is that the case is fixed on 5/8 before the trial court. So I prayed, can the matter be listed for tomorrow or on Monday, your lordship? It was allowed on earlier, but it was not listed.
Okay. What did not you mention earlier?
Lordship, I
Why
waited for,
till today?
lordship, because I thought that it will be listed.
Today is 1st of August.
Yes,
It was
29
supposed to be
it was.
listed on 29. You could have mentioned it on 30th. We could have taken consider yesterday. 5th.
Obliged, lordship.
Yes, may I please, lordship, I made some accommodation, lordship. Item 19 can be at 2 p.m. lordship. Please, ma'am.
Okay.
All, lordship.
My lord, I want to mention that regarding the listing of a criminal petition of 21 for the admission on Monday.
Not on Monday. It's possible either on 9th or on 12th. Up to you. 9th or 12th.
9.
May it please your lordship. Lordship, I beg to mention item number 24 and 33, your lordship. Since this is a long pending matter, we need to reconstruct the file and seek some instructions, your lordship.
Let the matter reach. Yes.
May I please, your lordship. Lordship, I want to mention regarding listing of criminal revision petition on Wednesday, lordship, for admission.
Wednesday board is full, ma'am. 9th or 12th.
Friday, then lordship.
On 9th. Not tomorrow.
I like to mention item number 40, lordship, 405. In the hearing list, lordship, kindly adjourn for 2 days, lordship. I am not prepared, lordship.
Let the matter reach. We'll see. Okay.
Yes,
May it
obliged.
please your lordship, I'd like to mention for listing of a criminal revision petition, lordship. Yesterday it was filed, lordship. Kindly this matter will be taken on Monday, lordship.
7th.
May I please, lordship. My lord, I wish to mention item number 34. The hearing matter, my lord. In this matter, Mr. R. senior counsel will appear, and he is suddenly went to Delhi yesterday, my lord. So any
Let
date
the
in-
matter reach. We'll see.
Obliged.
May I please also? May I please also? I would like to mention item number 15, 16 and 17 also. Mr. Esbotago is under briefman. So I prefer after 10 August. These are all series matter. Yes, Lordship. Lordship is consider, let the other matters go on. Lordship? Yes. One more pair, my lord, item number 25 will. Esbotago will appear. I prefer after 10. Item number 25. Yes, Lordship. Okay, let the matter reach. We'll consider. Value.
May it please your lordship.
Before taking up the matter, I'd just like to point out, my lord, so for the other matters are concerned, my lord, it's already admitted, my lord. Only because.
Only because of this
Yeah,
matter
yes,
and there is no
that's
stay
what I'm
order in
pointing
this.
out.
Motion.
We are already having a stay.
We know, accepting this in other.
Yes,
there
ma'am,
is-
that's why I pointed it out, my lord.
In fact, my lord, yesterday evening they have filed one affidavit, my lord. It is on merit, my lord, not on the issue of stay. So, my lord, this merit, of course, my lord, will be considered along with the other matters, my lord. As regards stay, my lord, my prayer would be my case also may be considered at par with the other similar cases. The issue being the same. So, on the date of the offense, it was not a scheduled offense. Number 1. Number two, my lord, my second argument is this, my lord. The CBI has already initiated proceeding in the matter. The CBI had investigated the matter, filed charge sheet. On the basis of the charge sheet filed by the CBI in the year 2005, proceedings are going on before the court, my lord. And the proceedings have reached the stage of evidence there. Now, lordship may kindly take up the complaint filed by the ED here. It is at page 126. They have not made any separate independent inquiry. And my lord, the charges herein as by the ED is similar in ditto as in the CBI charge sheet. So no independent inquiry has been done, only because there is an investigation by CBI. They have also initiated proceeding under the PMLA Act. My lord, I'm also referring to section 26 of the General Clauses Act, which says, my lord, when two acts where an act or omission constitute an offense under two or more enactments, then the offense shall be liable to be prosecuted and punished under either or any of these two enactments, but shall not be liable to be punished twice for the same offense. So this is my case here, that since the CBI court has already initiated proceeding and now at a belated stage, and at the moment when the offense was committed, it was not a scheduled offense even then. The offense is alleged to have been committed in 2005.
Yes.
Therefore, my lord, at this stage, without going into the merit, whatever they have filed yesterday, I have to file my, I have to go through it properly. I'm praying, limited prayer is this. Let there also be a stay in the further proceeding. In the special court, the matter is pending for framing of charges on 5th. So let this matter be also taken up along with the other matters, ma'am. Page 126, 127, lordship finds. This is the opening line as filed by the ED. The during investigation by CBI, it reveals that she so-and-so has committed this offense. So they have not made any investigation. They are relying on the investigation made by CBI. Then why, my lord, two proceedings for the same offense?
Yes, Mr. Debchand, what do you have to reply?
Worship,
Or-
my friend is in this matter.
Ms. Gayan, you have heard what is, Ms. Chakraborty is saying that there is no independent inquiry. Relied on the inquiry of CBI. The
Yes, sir.
proceeding of the CBI is going on.
Yes, my lord.
So why should this proceeding should not be skipped? Because
The PMLA is an independent act, my lord, and regarding the investigation, my lord, ECI that is that has been initiated and on the basis of investigation has been started, my lord. That is in page number.
but with regard to the same issue,
No, my lord.
the in other cases, there is a stay order.
Stay order is there, my lord. Stay order was granted on the basis of in my lord, item number 21020 Sunil Chopra, we have filed one affidavit in opposition, my lord, in that case. So in page number 32, my lord.
Hmm.
Page number, page number 31,
In the which
item
item?
number 2, criminal division
Just-
1020. Huh? Okay, that is not the one.
In item number 2, you are talking about, or item number?
Item 1020, item number 2, my lord.
Yes.
1020.
What do you want to show from there?
We have filed one affidavit in that case, my lord. Page
It will
num-
be common for all or it will be
common
also?
for all, ma'am. Page number 31 of my affidavit in opposition, my lord.
It was
Sunil Chopra,
filed by whom?
filed by ED, my lord.
Was the person, Prasanna Kumar,
Person is Prasanna Kumar Nayak,
permission to show? Which
my
page?
lord. Page number 31.
Twenty-one,
Yes, 31, my lord.
yes.
That is Obra Bulam case, my lord. This is the Supreme Court. On the basis of this case, my lord, interim has been granted. But in page number 32, the Honorable Supreme observation of the Honorable Supreme Court
Page
was
number 32.
32.
32, okay.
Observation of the Supreme Court was that, my lord, that should not be precedent. The order of the Karnataka High Court is should not be precedent, my lord.
Hmm.
That is on the basis of that all the cases that interim has been granted, my lord. But my lord, in Diganta Chakraborty cases, now my lord, in 2022, another case, the Honorable Supreme Court has passed out order in Vijay Madanlal case, my lord.
Hmm. Yeah.
Vijay Madanlal case, Honorable Supreme Court says that, my lord, this is
Do you have the citation of you?
page number.
Was decided when? Yes.
In Vijay Madanlal case, my lord, in paragraph 42, case number 285 of my compilation, my lord.
Hmm.
285, paragraph 42.
Page 285.
Yes, my lord.
Two eighty-five.
285, para 42.
Yes.
Here, my lord. For the mere language of section 3 of the 2002 Act, it is amply clear that that the offense of money laundering is an independent offense regarding the process of activity connected with the profit of crime which had been derived or obtained as a result of criminal activity relating to or in relation to the civil offense. The process or activity can be in any form, be it one, concealment, possession, acquisition, use of proceed of crime as much as projecting it is untainted property or claiming it to be so. Thus, involvement in any one of such process or activity connected with the proceed of crime would constitute the offense of money laundering. This offense otherwise has nothing to do with the criminal activity relating to the civil offense, except the proceed of crime derived or obtained as a result of result of the crime. Needless to para 43, needless to mention that such proceed or activity can be indulged in only after property is derived or obtained as a result of criminal activity. It would be an offense of money laundering to indulge in or to assist or being party to the proceed or activity connected with the proceed of crime, and as such process or activity in a given fact and situation may be continuing offense, irrespective of the date and time commission of the civil offense. In other words, the criminal activity may have been committed before the same had been notified as a civil offense for the purpose of 2002 Act. But if a person has indulged or continues to indulge directly or indirectly in dealing with the proceed of crime derived or obtained from the such criminal activity, even after it has been notified as a civil offense, may be liable to be prosecuted for the offense of money laundering under 2002 Act. For continuing to process or conceal or proceed of crime or relating possession thereof or use it is trans until fully exhausted. The offense of money laundering is not dependent or linked to the date on which civil offense, or if we say so, predicted offense has been committed. The relevant date is the date on which the person indulges in the process or activity connected with the such proceed of crime. These included are instinct in the original provision, and the same has been merely explained clarified by way of explanation by finance number 2000, the understood of inclusion. That is, my lord, date is not the relevant, my lord, as per the Bijoy Madanlal case. And that has also been in our case, few days back, my lord, in our High Court also passed in one order, my lord. Oh, 34. যাতে আছে নাই বলা
Yes.
Mala paragraph 30 Mala. Paragraph 30 Mala. That is our High Court order, Mala. The above aspect would be further clear from the further analysis of section 3 of the 30 Mala. Page number 28.
Yeah.
The above aspect would be further clear from the further analysis of section 3 of the Act. From the language so employed in section 3, it would show that the offense of money laundering is an independent offense regarding the process or activity connected with or with the proceed of crime which have been derived or obtained as a result of criminal activity relating to or relatable to the civil offense. The inclusion of various offense in Part A, Part B, Part C scheduled to the Act 2002 brings any criminal activity in relation to the civil offense and relatable to the civil offense within the fold of the Act 2002. At the cost of repetition, it reiterated that the process or activity as clarified in the explanation of to the section 3 of the Act of 2002 includes the concealment or possession or acquisition or use or projecting as an untainted property or claiming as an untainted property. Further, to that this process or activity would be the continuing activity and continuous till such time a person is directly indirectly enjoying the proceed of crime by any of the activity aforementioned. Therefore, the involvement in any one of such process or activity connected with the proceed of crime would constitute the offense of money laundering. The offense of money laundering is, in the opinion of this court, has nothing to do with the criminal activity relating to the civil offense except the proceed of crime derived or obtained as a result of crime. The Supreme Court in the case of Bijoy Mandala, that Malak I have already given, but Bijoy Mandala said dealt with the aspect of the matter, specifically in paragraph 270 and 296, and observe that it would be an offense of money laundering to indulge in or to assist or being party to the process or activity connected with the proceed of crime, and such process or activity is given situation will be the continuing offense, irrespective of date and time of the commission of the civil offense, my lord. Here my submission is that date and time is not the relevant, my lord. That is my submission, and that has already been observed by the Supreme Court and relied by our High Court in Akhtaruddin case also, my lord. So at that point of time, that other cases, my lord, this is not available, but this order has not been passed by the apex court, my lord. That where the stay is now operating, my lord.
No, Ms. Gunn, just tell us one thing. We understood that it is not a precedent, it should not
Yes.
be considered.
Yes.
Everything. But with regard to the same situation, when the other petitioners have appeals, or the petitions have been considered, admitted, and stay order has been passed, why we should not consider for this case?
My lord,
Show us the why it should not be considered for this case and other cases the court have already considered. Only this particular petition has been left out.
In fact, Lordship, in one of the cases, Lordship, I have filed an application for vacation.
That we know. So that is the reason we are asking it.
Yes.
That either we have to take that petition at first for all,
Yes,
or whereas in that case also we can consider the prayer made by Ms. Bhattacharya regarding the Ms. Chakraborty with regard to the stay of this, right?
Lordship, since the issue involved in all the matters.
And accepting
basically,
this, all has been admitted and stay order has been passed.
Yes,
That was the reason we are asking you.
Now, only thing that your Lordship has to decide is whether to continue with the stay. Because the trial is pending. It has been stayed. Now, in pursuance of the
We
order.
understood because what Ms. Chakraborty has submitted that it has come from the CBI inquiry, there you have date. And because it is independent proceeding, it has been found. That stand may not be to that extent, may be correct, right? But thing is this, when the other petitioners involving in the same issue,
Basically, Lordship has to deal with all the cases in one go.
that is why I'm asking you,
Has to,
why the petitioner in this particular should be separated and the other cases will be considered.
but otherwise, Lordship, I would barely submit till your Lordship takes up vacation petition. Maybe they.
No, that should be, basically, that should be stressed upon. That should be considered because I believe that is the first thing to do.
Yes. Yes. But
Leave it to
then
you.
these proceedings have been stayed for too long, from 2019 onwards, 17. That's also an issue that your Lordship has to ponder upon.
In one of the case, Mr. Bhattacharya, or 2 or 3 cases, Mr. Bhattacharya is appearing. He is under
He
bereavement.
is having some difficulty.
He is
so-
under bereavement,
Yes,
so
yes,
give us
yes.
a date when we'll consider all the matters together, at least that particular petition.
I think it's शनिवार रविवार के बाद। अरे, हफ्ता के सब दिनों में-
After 10th, 11th,
Oh, yes, Lord.
or maybe after 15th.
Lordship, as soon as possible.
No, I understood.
Yes.
before 11 of heavy
I'm
matter,
sorry.
11 of heavy matter.
Can it be on 13th, Lordship? It is a.
Possible.
It is a Tuesday, Lordship.
13th,
It is
August.
a Tuesday.
we will take it up.
Subject to-
Basically,
With all respect, 13 I will be out of station. Let it be somewhere on 16. 15 is probably a holiday.
16th is also good, Lordship.
we will not take up these matters on any motion
Motion day.
or admission day.
16th is Friday.
So it is to be on some Tuesday and
Then-
Thursday.
Then
In the week when we have both Tuesday and Thursday.
This-
So
Tuesday,
motion-
please. It's called Tuesday.
This day,
Tuesday,
Lordship,
Tuesday.
20th.
19th and, 20th and 22nd.
Yes,
We'll keep these 2 dates.
Lordship.
We are also indicating that from next Tuesday onwards and Thursday onwards, we'll be taking up only the hearing matters. Because you have seen in the cause list, 2011.
Yes.
Stay order. Right, we have also seen in various cases, 209 IPC, the ingredients are not there. There is a stay order
Lordship.
since 2011. 294 cases, that whether it's in public place or not, saying some slang words over telephone
That also has become 294, there is a stay. So from next week onwards, Tuesday and Thursday, only hearing and nothing else. Even if some matters are listed for admission,
Only hearing.
only hearing. Maybe some cases where there are applications for bail, appeal is pending. In those cases, we'll consider in order matters or something, but not, we'll consider only hearing matters. I think we have not looked into that. But this is a case, we'll have it on 20th,
On 20th, Lordship.
20th and 22nd, we are reserving for those today.
Yes, Lordship.
Mr.
My senior says
Yes,
he has got
Mr.
some
Kamar,
difficulty on
Mr.
20th,
Kotoki,
but he can take it on
this date
22nd.
is agreed to all.
Yes,
So on
ma'am.
those days,
Yes.
will not give any adjournment to anyone.
Yes.
Yes.
If somebody is having difficulty, the next concerned lawyer will do.
So I'll make my submission on 21st, my lord.
Not
not
on
20,
20 and 22nd, Tuesday and Thursday. Because everybody should be heard, so that's why it will take some more time. We'll fix it on some day. But with regard to the petition number 1, we'll have this stay order.
Till this is heard,
Yes,
Lordship. Till this is heard.
So that application will also be applicable in the case of Ms. Agarwal,
Yes.
right? Give her a
I will.
petition.
I will. I'll give.
In your case, you'll pass the order today itself, and then we'll fix it on 20th.
20th, rather.
Mr. Deputy Justice, that petition is item number?
Item 13, Lordship. I
RS Khan, ma'am.
have 546 of 24.
R.S. Khan.
Yes, Lordship.
Yes.
IA 546.
546.
Yes, madam. Item 13, my.
I'll supply a copy to my friend, Lordship.
I got it.
By tomorrow itself,
Yes.
Yes,
if not today.
yes. We have got it. Copy, sir.
Third, MSP Chakraborty, counsel for the petition. And item number 1. Who is appearing for 2? Who is appearing? You are appearing, ma'am? What's your good name?
P. Roy,
You are appearing on whose behalf?
Mr. Jayadalam.
Speak. Roy.
Roy,
Naam to
P. Roy.
P. Roy.
Current counsel on behalf of Mr. J. Alam, counsel for the petitioner. Mr. J. Kamal, learned senior counsel. Petition लिखी जब हाँ Mr. P. Kotoki, J. Kamal, 3, 6.
Shall I give the number, my lord? I
हाँ, that will
hear
be better.
3, 6, 7, 8, 13, my lord.
3, 6, 7, 8, 13.
Yes.
Mr. Kotoki, you are appearing for?
Yes, my lord.
Only 4.
Yes, ma'am.
Where is Mr. Burman?
We, to property.
Who is representing item number 5? Okay, we'll make it no representation.
Oh, I think.
7, come on.
As per what?
Mr. Bora, you are appearing for 8?
Yes.
8 and
8, Mr. Kamar is appearing.
8 and 13, my lord.
Along with.
8 and 13 are RS.
You are appearing for 9?
9.
Who is appearing for 10?
P.K. Mahajan. P.K. Mahajan. 9.
11?
Lordship, I am appearing for 11. 11 and 12, madam.
10 not represented. 5 not
On
represented.
7, with all respect, on 7, I and Begum is appearing, my lord.
7
Ranveer
and
Singh Gandhi's case.
7 or 10 Begum.
7, no.
12, you are
11
appearing.
and 12.
11 and 12, 7 I am appearing.
For 13 you are appearing. Mr. Kamar?
13 here. I have given 3, 6, 7, 8, 13, my lord.
Majority of cases, he is appearing, ma'am.
No, no.
So, let him answer the case.
For
No, I only took the stay order. You all just follow
14,
suit.
14.
It was I who took the order, then you all showed it.
Who is appearing for 14?
14, my lord, I don't know what it's one.
Alright.
Okay. 15, 16 and he is under bereavement, we understood.
15, 16 is what happened?
Oh, Botakur is under bereavement.
Different,
Oh, it's different.
Different.
1 to 14.
1 to 14 only.
14 could not represent. No, 14 is not represented. Item number 14.
14 card number.
Mahajan
Mahajan only.
One order to pass.
No, Jalan.
MSI current.
That's the Kuruma.
Standing council and for.
Oh, the no Gampai. Apani bhi taking.
As agreed by the land council for the parties. Place this matter on 28th of August for consideration of IA criminal 546/2024
এখানে ইতিয়া ক্রাইম করব কেন তো নর্থ ইন্ডিয়ান মানে ইয়াতে
filed in criminal petition 334/2019
তো একদম কেজন মেনে আছে
wherein
নেহতে ভাবে অফিস চলে
The
বহুত আছে তো
Union of India
আমাদের কাছে যে ল
the petition for
20th. 20.
vacation of the interim orders passed in
ওকে অথরাইজ
these sets of criminal. Yes, you are appearing for
For 10 and 14, my lord.
10.
10 and 14, my lord.
অথরাইজ মাতি
Now only 5 left out.
Manam.
Okay, Mr. Chakraborty will pass this.
We can take leave, my lord.
Yes, it will be on 28th now.
Yes, my lord.
My lord, will record my name also, my lord, I am a
Oh, yes.
ED, my lord.
Oh, take it. And assistant solicitor for the. This Diane, this your compilation and this for the time being will keep it.
Yes, ma'am. Lagi tu mai tin. Lagi mana? Lagi nak kasih nak tak itu.
Another 13. You mentioned 15 and 16.
15, 16 and 17 also. 15, 17 is middle and also
In
20.
this council, in these cases.
15, 16 is actually that MP MLA. Of course, he is in bereavement, I'll not object. But then division bench is monitoring.
15, 16.
So-
60, I think. In these 3 criminal petitions. Filed by the same petition. Is led by Mr. S. Botakur, Planet Council. Who is present here.
17 also.
Bereavement. In view of the above, list these matters on 28th of August.
Also, one more item, madam, item number 25 also.
Let the matter reach, will pass on.
Let's see. Value of the-
May it please the Lord.
Junior with it. My junior.
Madam, the 482 application in respect of a proceeding initiated under section 107 and 145 of the CRPC. My lord will find the impugned order at page 39. The order passed by the learned executive magistrate, my lord.
Page
39, my lord. Annexure 5, my lord. My lord, in this case, the petitioner and the respondent number 1, my lord, the families had been disputing over possession of the scheduled land, my lord, for a considerable amount of time. In this regard, my lord, this proceeding was initiated by the respondent number 2 under section 107 and 145.
yes.
My lord, may I read the order, my lord. There are two parts of the order, my lord. Regarding one part, my lord, we have no objection. This is only one part we are assailing, my lord. May I read, my lord? CR received on transfer, peruse the complaint petition and the police report. Also peruse the letter issued by the circle officer, Topoka Revenue Circle, white letter number such and such, dated 14/7/2021, addressed to the officer in charge, Morazar Police Station, regarding deputation of police personnel in cultivation land at Terapur village as per schedule of land as mentioned below. The undersigned also directs the OC Morazar PS to depute the police personnel in that area during cultivation only by the petitioner, on being satisfied that there is an apprehension for breach of peace and tranquility. So I am drawing a proceeding under 107/145 CRPC. Both parties are directed to appear before the court next date fixed on such and such. My lord, regarding facing the proceeding before under 107/145, the petitioner is not challenging that part. We are willing and ready to face the proceeding. It is only regarding, my lord, this direction passed by the learned executive magistrate, that is directing the OC Morazar PS to depute police personnel in the scheduled land to allow cultivation only by the petitioner being the respondent number 1 here in my lord. And in this case, both parties are claiming possession of the land. Petitioner specifically is also claiming that he has possession over the land. So this part of the order, my lord, effectively ousts the petitioner, my lord, from the possession of the land. So, my lord, the proceedings under 107 and 145 CRPC, well, these are emergency powers which are given to magistrates to exercise in order to ensure that there is no breach of public peace and tranquility, and also to ensure status quo, my lord. These provisions are not intended to alter the possession of the land, my lord. So our humble contention before this honorable court is that we are ready and willing, we'll go and face the proceedings. This part of the order, my lord, this may be kept at abeyance, my lord. Let the executive magistrate hear both parties and see if there is actually a possible breach of peace and tranquility, because this dispute has been going on for almost 40 years, my lord. And this order was passed in 2021. Subsequently, a revision was preferred, which was dismissed, my lord. But till now, my lord, there has been no untoward incident, my lord. So, my lord, let the parties face the proceeding. Let this part be kept at abeyance, my lord.
Yes, Mr. Chaudhary. Only thing is that
My lord,
what is the claim by the
the impugned
petitioner?
order, the impugned
No, no,
order at,
we want to just know.
my lord, your lordship
Because-
will find
Yes,
the impugned order at page 45 has been set aside. My lord, 92 1 SCC page 1 paragraph 10. After setting aside, how he comes over against a revision without saying that the revision order is not under challenge.
There is also.
Please. Now let me finish. Revision order, it has set aside that order and only asked that you people go there and appear before that court. The revision order is at page 45. And at page 49, the court has said, the court refrains from dealing with the factual matrix of the case. However, this court is of the considered, finds no illegality and infirmity of the order under such and such, preventing any interference by the revisional court. The revision court has refused to interfere with that order. They approached for a revision against that order. The revisional court refused to interfere with that order against that which they have come for 482. Now they are again placing that order. And now, my lord, I take your lordship to the police
come
report.
to page number 15.
15, your lordship will find.
Yeah.
It is their prayer, my lord,
Hmm.
to call, to set aside the 37 order and along with that, the revisional order.
Hmm.
My lord, now your
So
lordship will
against
find,
order, criminal petition can be filed, why not?
my lord, 482, it can be filed, my lord. I take your lordship to the police report. Page 27. They only say that, my lord. Page 27, third paragraph, middle portion. They are the second party.
Hmm.
The second party did not show the documents. My lord, further, the first party have been claiming to be in possession of 60 acres of the scheduled land situated in such and such since 1982-83. The second party also claims to own the below scheduled land, but when asked to produce the relevant documents, the second party did not show the documents. There is a reasonable apprehension of the altercation taking place between both the parties at that moment. As such, it is humbly prayed that under section 145 CRPC be registered, and after inspecting the land documents to below scheduled land of both the parties, the land be handed over to the actual owner. That was the police report. And on that basis, the order was passed on 37. And both the parties were asked to appear before that court. And the revisional courts gave a stay order. And with that stay order, they continued for a quite longer period. The stay order was passed on 7/8/21 against the order of 37/21. Stay order was given on 7/8/21, and that ultimately it was dismissed revision was dismissed against Malad on 28/11/23. At 7/8/21, there was a stay order, Malad.
Mr. Roy Chaudhary,
My lord.
kindly read the vernacular at page 29.
Page
29. It gives some other indicator. Yes, instead of you, will you able to read? Ms. Das, come forward. I think you will be able to read.
গতিকে মহামান্য তদন্ত তলব গলত পদক্ষে মাজত ধোৱা ইমান চনৰ পৰা বাকী
It's not that.
60
এজাহাৰবিহীন গোচৰৰ চমু বিৱৰণী এখন প্ৰথম পক্ষই মাননীয় হোজাই জিলাৰ আৰক্ষী অধিকাৰৰ পৰা অনা something গণৰ মতে স্থানীয় জমিত চাগে তদন্ত স্থানীয় জমত কপাহবাৰী গাঁৱত গৈ অনুসন্ধান কৰি জানিব পাৰিলো যে প্ৰথম পক্ষৰ ঘৰ কপাহবাৰী, দ্বিতীয় পক্ষৰ ঘৰ উত্তৰ ডিমৰু পাৰ। তদন্ত কালত দেখা গ'ল যে পক্ষগণৰ মাজত যোৱা ইংৰাজী 1982-1983 চনৰ পৰা কপাহবাৰী মৌজাৰ তাৰাপুৰ কিছামতৰ 60 বিঘা মাটি লৈ পথাৰ পক্ষৰ দুয়োৰ মাজত কেইবাবাৰো হাই কাজিয়া হোৱাৰ উপৰিও উক্ত মাটিখিনি উভয় পক্ষই নিজ নিজ মাটি বুলি দাবী কৰে। উক্ত ঘটনা লৈ পক্ষদ্বয়ৰ মাজত something যিকোনো মুহূৰ্তত গুৰুতৰ শান্তি ভংগ দিয়া or something আশা কৰাৰ কথা দিছে। ওচৰ চুবুৰীয়াই শান্তি ভংগ হোৱাৰ আশংকাই দেখা দিছে। গতিকে মহামান্য আদালতত ফৌজদাৰী গাছা বিভিন্ন আইনৰ 107 ধাৰাত এটি গোচৰ ৰুজু কৰি সমন বা নোটিছ যোগ পক্ষ দিয়াৰ আদালতলৈ মতাই নি পক্ষদ্বয়ৰ কি কাৰণে শান্তিৰে বসবাস নকৰিব তাৰ উপযুক্ত something তলব কৰি কমেও 1 বছৰ কাল শান্তিৰে বসবাস কৰাৰ বাবে পক্ষদ্বয়ক কঠিন সুযোগ কৰাৰ বাবে প্ৰাৰ্থনা জনালো। পক্ষদ্বয় নিজ নিজ সাক্ষী আদালতত হাজিৰ কৰাব। Now this This you read very carefully. প্ৰথম পক্ষই কপাহবাৰী মৌজাৰ তাৰাপুৰী কিসামতৰ নিম্ন তফচিলৰ জমিৰ 60 বিঘা মাটি প্ৰথম পক্ষই 1982-1983 চনৰ পৰা ভোগ দখল কৰি থকা বুলি দাবী কৰাৰ উপৰিও
So Mati,
উক্ত মাটি নথি পত্ৰত থকা বুলি দাবী কৰে. They claims but not shown.
But not sure.
দ্বিতীয় পক্ষগণেও উক্ত তফচিল বৰ্ণিত মাটিত খিনি নিজৰ বুলি দাবী কৰে যদিও উক্ত মাটিখিনি কাগজপত্ৰ বিচৰাত দ্বিতীয় পক্ষগণে কাগজপত্ৰ দেখুৱাব পৰা নাই.
Nine.
উক্ত মাটিখিনি লৈ পক্ষদ্বয়ৰ মাজত যিকোনো মুহূৰ্তত
Danga Hor.
দংগা ফসাদ হোৱাৰ সম্ভাৱনা দেখা যায়. সেয়েহে মহামান্য আদালতত ভাৰতীয় দণ্ডবিধি আইনৰ অধীনৰ 145 ধাৰাৰ এটি গোচৰ ৰুজু কৰি উভয় পক্ষৰ উক্ত তফচিল বৰ্ণিত মাটি কিনি কাগজ পত্ৰ চাই মাটিত প্ৰকৃত গৰাকীক সমজাই দিয়াৰ বাবে মহামান্য আদালত প্ৰাৰ্থনা জনালো.
That is what I am saying, my lord. Let me.
Rightly, you are right, one way. But it is not a fact that the respondent number 1, who is the person concerned, the first party therein,
My lord.
had shown the documents. He said that he claimed that
No,
he
no, I
has
am
the
not saying
document.
that I have shown the document.
But
What I am
what the
saying,
respondent number 2, with the present petitioners, when they say that they have the documents but could not
show the documents.
But this report clearly shows that who is in position, there is no finding.
My lord,
And secondly, to read the last line, what is that? 145 ধাৰাৰ এটি গোচৰ ৰুজু কৰি উভয় পক্ষৰ উক্ত তফচিল বৰ্ণিৰ মাটিত দিয়া কাগজ পত্ৰ চাই মাটিৰ প্ৰকৃত গৰাকীক চন্দাই দিয়াৰ বাবে.
my lord,
It's not that, see, there was no document before the learned executive magistrate
my lord,
when allowing the respondent number 1 to be there in that particular land of 60 acres.
my lord, what I placed, my lord.
That is what the report is. Neither you, nor the counsel for the petitioner, nor the court was there. It is the report. We have to go through the report.
My lord,
There has to be some basis on that report
my
that the respondent number 1 was in possession.
lord.
There is no finding from the report, in that report, that respondent number was in possessing that land. Or he is in the occupation of that and cultivating that land.
And in the translation, it is not written that first party could not produce the documents, although they claim.
But that's the translation is of the petitioner.
Petitioner, not mine.
Not the, by Mr. P. Roy Chaudhary. So it is up to him. That is why it is very important.
My lord, what I want to place, in the police report, it says that I claim to be in position.
No. There is, he said that he has the document
My lord,
regarding the land. He
at
has
page
the, it is not
30,
that he produced the land.
my lord, at page 30, your lordship will look into that, পদপক্ষে কাৰ্যালয়ৰ ভিতৰত নিম্ন তৰফত such and such
60 বিঘা মাটিত প্ৰথম পক্ষই 1982-83 চনৰ পৰা ভোগ দখল কৰি
কৰি
থকা
আছে।
বুলি
That is-
দাবী কৰে।
দাবী কৰে।
দাবী কৰে।
But my claim was possession, and their claim was that they have right title interest. That your lordship will find.
1982-83. But
But I am in position.
it is a report of, it is not that,
My lord, both of us can go there and face the trial, my lord. What is there?
so but why only?
On what, if they want to do anything, let them file an application before that court. Why before the High Court in 482, my lord? When the revision court has said that we will not interfere, and the finding of the revisional court at page,
What are the materials, but Mr. Roy Chaudhary, in this particular report, there is no such finding. Just read it, that's why I was going through it.
page 48, your lordship will find, page 48, the finding is there. Page 48 of the revisional court judgment, my lord. Page 48, last 3 lines of the paragraph 9. It is also seen that both these provisions are temporary in nature, and the parties may approach the executive magistrate for modification of the aforesaid order. The only requirement for invocation of 107 and 145 is there should be an apprehension of breach of prison. The executive magistrate has to satisfy that there is enough ground for dispute between the parties, either for possession of a land or otherwise. In the instance case, it is seen that the executive magistrate had based his subjective satisfaction on not only upon a complaint, but also on the basis of a police report and a report from the circle officer. My lord, that being so, it cannot be said the executive magistrate has acted without any material. which would enable him to arrive at any subjective satisfaction. Since the petitioner has challenged the initial order passed by the executive magistrate summoning both the parties to appear before it and present their respective cases, and the trial court has still not ventured into the merit of the case itself, this court refrains from dealing with the factual matrix of the case itself. However, this court is of the considered finds no illegality in form of such and such and such. The court does not find any merit and the revision petition is dismissed. He is virtually in a second revision, my lord, in a 482, or an inherent power of, my lord, coming with a provision of the inherent power. Both of us will appear before that court and let them file an application before that court, and the court will decide. And moreover, my lord, this is an interlocutory order. It has not affected any of the person's right.
In this regard, I'll humbly disagree, my lord, because as far as appearing before the learned executive magistrate is concerned, my lord, we are ready and willing to do that. The only part of the order, my lord, where the executive magistrate directs the police personnel to allow only the respondent number 1 to cultivate the land.
That can also be done by the executive magistrate. If there is a finding from the High Court, my lord, if a finding from the High Court, my lord, then they will not interfere with.
So my lord will keep that part in abeyance, my lord will go and face the.
No,
because
my
we
lord,
are
why
going
there
to-
should be an abeyance of that part?
That part, my lord.
Why there should be an abeyance? Your lordship will dispose of. In a 482 coming, my lord, rarest of rarest case, my lord, they will come over here. Whoever in position, they will definitely, during the cultivation season, my lord, he will do the cultivation. He cannot show the documents, he cannot produce the documents. The order was not vacated. And we came before the High Court in a revision application, my lord, against that stay order. My lord, against that stay order, we came before this High Court, my lord, and there was an order passed by this court, my lord.
Just a minute.
It is illegal. Against the stay order, we approached this court, my lord. And the circle officer's report is not there in the petition, madam. The revisional court's finding was there on a police report and on a report from the circle officer. But the circle officer is not been annexed here with the petition, madam.
Here in this particular police report, if you read the last line, case 30. It is very clear, if you read, সেয়েহে মহামান্য আদালতৰ ভাৰতীয় দণ্ডবিধি আইনৰ 145 ধাৰাৰ এটি গোচৰ ৰুজু কৰি উভয় পক্ষৰ উক্ত তফসিল বৰ্ণিত মাটি খিনিৰ কাগজ পত্ৰ চাই মাটিৰ প্ৰকৃত গৰাকীক সমজাই দিয়াৰ বাবে মহামান্য আদালতত প্ৰাৰ্থনা জনালো।
Madam, we will place our documents.
That part is that because till then, who is in possession or who has the documents does not placed before him, and he has mentioned there is an every possibility of
Breach of
reason.
peace.
So that is the reason. Here there is no such thing. Now, if there was some documents before the district magistrate or that is executive magistrate, and then there is a report of the circular officer, we do not know, that has not been discussed by the concerned executive magistrate. And also, you are aware that there are various judgments with regard to this, our High Court, the Honorable Apex Court, that it is seen that the parties, when the matter relates to dispute in the land, instead of filing a suit, what they take recourse to the 145%. Because it is short process. Once they get any order from the executive magistrate, they will be in deposition. So that's how the shortcut method, whether in, you will see various judgment in 482 should not be encouraged. Because they have to approach the appropriate court. But here only thing is, the executive magistrate allowed the respondent number 1 to be in possession of the land. But there was no such document before the magistrate or a report. Because as you have seen, the report of
that
the
period,
concerned police.
that period of 21, my lord, now it's 24. That period is over, my lord. That period of 21, now it is 24, my lord. There was a stay order, and during that time, my lord, it was over.
Sir, let the parties appear before the executive magistrate.
Magistrate,
They
and
will
this is,
agitate their own claims, my
well,
lord.
that is what I'm
The
trying
only
to.
thing, my lord, with this finding, my lord, if it goes again back to the executive magistrate will, this or this part of the order will be enforced, my lord.
Because 21 and
I will be
24, my
ousted
lord.
I will be
These
ousted
3
of-
years, my lord. These 3 years, my lord. Your lordship will clarify. This order reflects to the cultivation of year 2021, not of 2024. That aspect of the matter, will lordship will clarify. This cultivation relates to the year of 2021, not of 2024. That aspect of the matter, I am, my lord, quite agreeing to that, my lord. Your lordship may state that, clarify that position. Because this order was stayed by the session court, my lord, for 2 years.
During that revision petition.
Yes, my lord. That stay order is, they have annexed, my lord. 7/8/21. Your page 43, my lord. 2 years they have kept its stay order. And my lord,
Do you have a copy of the letter of circle officer of 14?
my lord, that I don't have, my lord.
The records have been called for, my lord. Records are available. Because we also could not find that report, my lord. That was not provided to us.
But Mr. Roy Chaudhary, here there is no such mention that it was only for that particular year.
Yes, sir.
Because the year of 21, my lord. Order is of 21. Cultivation done for every year, my lord. Your lordship will clarify that. This cultivation relates to a year of 2021, not of 2024. Your lordship will clarify that and dispose of the matter and send back, my lord, for both the parties to appear before the trial court. Will clarify that aspect of the matter.
Just
21, 3 years now. My lord, in that order of 37, also peruse the letter issued by the circle officer, Doboka Revenue Circle, dated 14/7/21. Addressed to the officer in charge, Murjabhar Police Station, regarding deputation of police person.
It is available in the record. Take your seats. Take it. Yes, these reports clearly reveals that respondent number one is in possession of the land. There are reports of the circle officer, mandal, everything. And report of the concerned Gaumbura of that land. What had happened basically, the petitioners during the time of the Janata curfew, because of the lockdown, what they have done, this particular land is adjacent to the house of the present petitioner. They have entered into this land, in one part of the land, and built a house, thatched house, temporary. And they also tried to enter into a land by removing the post, boundary post, but they could not enter. So it is not the entire 60 acres of
60 acres of land.
but only relating to a particular portion. The villagers of this area, where the land is, the concerned Gaumbura, the Mondal inquired, Mondal said, in these other cases, even on that particular disputed land, the respondent number one is in possession.
Of the entire 60 acres of land.
at 57 something, what given the list. And the report reveals that even on such disputed land, it is the respondent number 1, present respondent number was the complainant, Mizanuddin. He is in possession of the land. And the circle officer also, initially the report was of the Mandal. Then circle officer himself went to the place of this particular. Then he inquired into it, found everything. The villagers came, and the Gaumura came. In presence of that, found it is the petitioner, that is respondent number 1, is possessing that land. And that is what reason. And the Mandal very specifically mentioned that they have already, since they are in possession of the land, they have prepared to cultivate that land. Maybe for this reason, the executive magistrate passed that order, allowing them to cultivate in presence of police personnel and to complete the harvest.
My lord, subject to my correction, with all my humility.
That's the report.
Well,
It's all in vernacular.
145(4) on this evidence, under 145(6) can put the person in position and do it, my lord, what I understand.
We'll go to that. Just a minute.
145, and 145.
That may be the reason, because of the report of the
Circle officer.
Mandal, the circle officer and other people. It is clear that executive magistrate passed that order allowing the respondent number 1 to
Continue with the cultivation.
in fact, Jamabundi and all, everything is in favor of the respondent number 1. There is also a particular land which the father of the respondent number 1 purchased. And their names were incorporated in the land record. But the present petitioners objected. And that is why the name of the father of the respondent number 1 is deleted from the land record. But though the particular land that was purchased by the father of the respondent number 1 was deleted from the land record, it is the respondent number 1 and his family is in occupation of that land. That is also been clarified.
In the report.
Probably this is the reason why the executive magistrate, after going to the report of the concerned Mandal, the circle officer and the villagers, have allowed the respondent number 1 to cultivate and not for others. Now you tell us what to do. These are the reports in the record.
Yes, my lord. I mean, if those are matters of record, my lord, I have nothing to submit, because from whatever materials
We understood.
Are
There has to
at all
be
disclosed.
why the otherwise the executive magistrate allowed to detect
That
the
kind of-
cultivate the land when there is a proceeding under 140.
144.
And the police report is very clear, there is danger in.
The of apprehension was there.
So, tell us.
In that case, my lord, will appear, if that is the report, my lord, we have now, we cannot say something beyond the report, my lord.
Right.
So let both the parties, my lord, appear and fight their claims before the executive magistrate. my lord.
Maybe this report was also examined by the.
By the executive magistrate.
While it's
My lord.
ordered in the revision petition. You wanted to point out 145 here?
145(4) and 145(6). 145(6)(a).
But here,
It is after evidence.
Evidence,
ma'am.
ma'am.
It is after evidence.
there is no such evidence because.
Only I can say that report from the circle officer, that much. We'll appear before the trial court, ma'am.
You have to appear before the magistrate.
Magistrate.
and
Magistrate.
Give us a date, we'll fix it.
Let me August.
August, last week of,
Last week of August, ma'am.
my lord,
29th August.
29th of August, my lord.
The report of the investigation officer, the investigating officer played a safe role.
Right.
He did not part with anything. It is the circle officer's report which indicates and everything. And the Mandal indicates and everyone other day indicates that respond number 1 position of the line. Heard Mr. Asda,
Yes, Nawaz, my lord.
as Nawaz, sorry. Learned counsel appearing for the petitioner.
My lord, sorry, my lord.
And Mr. P.K. Roy Chaudhary, learned counsel appearing for the respond number 1. Also heard MS as Zahan, learned additional public prosecutor. For the state respondent. Twenty-ninth of August.
29th of August, my lord.
We'll dictate the order in the open.
My lord.
After some time. We'll complete the order matters first. Then
I'm deeply obliged, my lord.
you may not be there. We'll dictate it and send back to magistrate on 29th.
Deeply obliged.
But one thing just,
My lord.
Mr. Roy Chaudhary was placing that you have annexed some other order whereby it will stage or
Oh,
something.
my lord, that was regarding the revision. Against this order, we had filed a revision. There was a stay. Subsequently, this was, my lord, the revision was dismissed, my lord.
No.
I'm obliged, my lord.
Net.
May I plead your lordship? As per office note dated 29/7/24, your lordship, probably service is not complete, your lordship. I think there is a delay. Condemnation of delay,
Kiman delay?
293 days.
293 days. Otherwise, condonation of delays between the court and the parties, lordship can decide on that. কি আছে?
Appeal
Offense
against
to-
acquittal.
appeal against acquittal. Offense to keep. Offense to keep.
And then I may be allowed to take fresh steps along with concerned OC of the police station.
You have a copy of the FIR? Do you have a copy of the FIR that we have, because it has not been annexed here?
I don't have, yeah.
In the judgment, there is no such address of the respondent number 2.
Yeah, okay. I have the certified copy of the GL case order,
The judgment you have.
judgment and the order,
The deposition also. I think.
depositions also,
You
yeah.
have deposition, give it to us.
Then.
But
Lordship
that
will get-
will, okay.
Now deported. I'll just see whether it is there. No, these are order sheets. FIR is here, FIR is here.
Definitely in the FIR that
Last-
address. Or in the. Was he arrested?
Yes, Your Honor. He was in jail and subsequently released on bail
By which court?
by this honorable court.
Sharma. Tomburu Rohang. Tomburu Rohang. Aruitin.
No, এটা ডিসপ্লে লাগে ইয়াতো ওলাব চাগে এফআইআৰটো ওলাব নেকি এই কেতিয়া হেৰি লৈছে বাৰু ইয়াতো
Mayur Reddy. Alright. Let me go. So we go down. MS F. Hussain, counsel for the applicant. NMS S. Zahan, learned additional public prosecutor. Appearing for respondent. There's a mistake in the numbers. Page number 2 of the application, if you have a copy.
Yes.
Where was the office note? Dated 29/07/2020. On being inquired, Ms. Right, and counsel for the applicant. Place the records of GR case number 10897 of 2017 arising out of Vasishtha. Yes, case number 720 of 2017, wherein the learned Sub-Divisional Judicial Magistrate put in bracket Sadar, bracket close number 2, Kamrup Metro, Guwahati, by judgment and order dated 26/06/2023, acquitted the applicant number, sorry, respondent number 2. From the said record placed by Ms. such and such, record of GR case, it is seen the address of the respondent number 2 is dash people. Pambaru Rohang, SAMBARU, Rohang, ROHAN, son of late Doibo, DAIBA, Ram, separate, Ram Rohang, ROHAN. Number 2, Moiram Gaon, Gaon, Police Station, Vasishtha, District Kamrup Metro. Rama, Oguti, Kariwat. The positions are here or not there?
Yes, yeah.
As such, the applicant is directed to take first steps on the response number 2. I'm 250. But it's the possibility on OB4. 6th of 7th of August. List on 6th September. Take back.
Deeply obliged.
Lordship, I have filed one IA Lordship under section 125(2) of the seeking interim Lordship maintenance. As the order has already been passed by the Family Court CJR Lordship, till date, they are evading payment Lordship. On last occasion in July 5th or 6th Lordship, the date was there. On that day Lordship, as per the order that I have not annexed with this, but in the petition it is annexed Lordship. Their Lordship, 10,500, this is the maintenance amount that is to be paid per month. That has been passed by the Family Court Silchar Lordship. But against that Lordship, in the execution case, he has paid only rupees 5,000. And till date Lordship, I have mentioned in the IA Lordship, in paragraph 7, page 5 Lordship, I have stated that what he has paid till date Lordship. He has paid till date only 16,000, twice 6,000, and one occasion this was 4,000. This was paid, and on last month Lordship, in the execution proceeding, when the matter was taken up, he paid 5,000 only out of 10,500 per month. Lordship, the petitioner, she is unable to maintain her Lordship, and she has a child also, which is not been taken care of by the petitioner Lordship here. She is now been taken care of by her mother Lordship, who is also in about 80 years of age Lordship. She also lives in a very meager family pension Lordship, because her husband, he was a grade 3 employee in the forest department Lordship, and he retired in early 90s. So whatever amount she gets Lordship, mostly spent on her medical treatment Lordship, because she is old and aged, and she also is suffering from various other ailments Lordship. So now Lordship, the petitioner is unable to maintain, because of this Lordship, the child is also suffering. The child is also, she also cannot able to give this child a proper education Lordship. And that apart Lordship, they have come before this honorable court seeking quashing of the order passed by the Family Court Lordship. So in that matter, Lordship, she is unable to maintain, and she is unable to maintain that means to cost of the proceeding as well, Lordship. So we are before your Lordship seeking indulgence of your Lordship, passing for appropriate order in this matter, Lordship. And on the last occasion, Lordship, they are showing that they have filed a case before the High Court, Lordship, and the court below, they, Lordship, did not take up the matter properly, Lordship, because of pendency of this case. Even though no direction has been passed, Lordship, I have the certified copy of the order, Lordship. The respondent has been all along telling he has filed a case before the Honorable High Court, and that's why he is not pursuing the case there, Lordship.
Mr. Via.
My lord. My lord, my lord.
Read quickly para 7, 8, and 9 of the
Judgment.
judgment. That,
Fine.
that starts at page 44.
Para 7, my lord.
7, 8, and 9.
My lord. Yes, yes, my lord. Now, going through the case record, my lord, it transferred that in her evidence. My lord. Transferred that in
Yes,
her
Lordship.
evidence, the first party adduced evidence corroborating the contents of her petition, and the opposite party could not disclose her testimonies in cross-examination. The first party in her evidence testified on oath that her marriage with the second party was solemnized on 11/6/2014 as per the Hindu rites and customs at the Panchanan Shivbari Malugram, and after marriage she started her conjugal life at the house of the second party at Badarpur. She further testified in her evidence on oath that the second party took her to Rajasthan, where he was doing a job, and from there the second party started neglecting her in providing maintenance. According to her, there she became pregnant by the second party, and during her pregnancy, the second party brought her to her paternal house, and by leaving her there, he went back to Rajasthan. It is testified that in May 2015, her son was born, and all expenses of his birth was borne by the father of the first party in spite of the due information by the first party and her family members. Till 2018, she was at her parental house, and during this, the second party did not provide any maintenance to her, sorry, my lord, and her child. According to her, after such persuasion in December 2018, the second party came to Silchar and took the first and her child to his place of work in Lucknow. But here also he neglected to provide maintenance to the first and her child, and also physically tortured them, for which, unable to bear such torture, she had again come back to her parental house at Silchar. Thereafter, in April 2019 and November 2019, she again went back to the place of work of the second party at Farrukhabad, where the second party repeated his earlier misdeeds in neglecting to properly maintain the first party and her son, and also did not stop in harassing the first party and her son both physically and mentally, for which the first party was compelled to come back to Silchar and took shelter at her parental house in March 2020, and since then she has been living separately from the second party. According to the first party, the second party is a teacher by profession and earns rupees 40,000. So she prayed for awarding maintenance at the rate of rupees 15,000 per month to her and the rate of rupees 5,000 to her son. Though the second party cross-examined the PW1, but except confronting her with some suggestion of denial, failed to twist her evidence in any manner, thereby leaving her corroborative evidence in fact. As stated above, the second party also examined his DW in record, and his evidence fortified the case of the first party in material particulars like marriage between the parties, paternity of the child, and that they came back from Farrukhabad to Silchar in 2020. In his evidence, the DW1, traveling beyond his written statement, brought in record new facts that at Badarpur the first party deserted him, or that during lockdown period the first party demanded rupees 5 lakhs from him, or that the first party threatened him or cross litigation if he fails to fulfill his demand for money, or that while returning from Farrukhabad he handed over rupees 3 lakhs to the first party, and the first party, without handing the money, deserted him at Badarpur. Needless to note here that the evidence beyond the pleadings is not admissible in evidence. Now, nowhere in his pleadings or in evidence, the second party deny that having sufficient means he neglected to maintain his wife and child. There is no evidence in record that the first party has her independent source of income to maintain herself. Mere admission in record that the first party is an MA in English with the first class B.Ed degree is no way evidence in record to establish the fact that she is able to maintain herself. There is no denial that the second party is serving as a teacher in the Central Public School Patharkandi, and his salary statement produced by his employer goes to show that his monthly gross salary is rupees 40,000 and net salary is rupees 37,125. From the above discussion and scrutiny of evidence on record, the point number so and so is decided in affirmative in favor of the petitioner.
9 and 10.
My lord. While deciding the point number 1, we have already come to decision that the petitioner and her minor son is entitled to get maintenance from the second party. Now question obviously arises as to what would be the quantum of monthly maintenance which can be considered just and proper. To determine the quantum of maintenance, I am to look into the capacity and income of the answering opposite party. Admittedly, the opposite party is a salaried employee under the Central Public School Patharkandi, and his gross salary for the month of May 2023 was rupees 40,000, and after deduction, the net salary stands at rupees 37 so and so. Taking into account the basis requirement of the petitioner and her minor son in the present days of rise of essential goods and the capacity to pay by the opposite party, I am of the considered view that awarding rupees 7,500 per month would be the just amount of maintenance of the petitioner and rupees 3,000 for the minor son in this case. Accordingly, this point number 2 is decided in favor of the petitioner. In view of the decision arrived at of the point number 1 and 2, it is ordered that the opposite party shall pay monthly maintenance of rupees so and so per month to the petitioner and rupees 3,000 per month to his minor son till attaining the age of majority with effect from the date of passing of this order. The case thus stand disposed of on contest, however, without any cost.
So this is the finding.
Not this. My lord,
So why
absolutely, and
the petitioner did not deposit the amount with the number 1, the complaint here. Why?
my lord, my lord, our instruction, my lord, is that, my lord, that he is trying his best, and even in fact in the last few dates, my lord, he has started paying, my lord, some amount, my lord. Because, my lord, what is happening, my lord, although my salary has been sought to be 40,000, my lord.
That's your salary certificate.
No, my salary certificate, that is correct, my lord, but the school authorities is not paying practically rupees 40,000, my lord.
That is
Only, my lord,
37,000, whatever is there.
no, my lord, only 24,000 has been paid, and this is purely a privately managed school, my lord. Although it has been marked as a central school, but it is not a Kendriya Vidyalaya like institution, my lord. That's why, my lord.
That you could have placed it before the. But you have not made it.
That is correct, my lord. My lord, even today I am agreed to take care of my wife as well as my child also, my lord. My lord, but the only problem is that, my lord, the wife voluntarily deserted with some baseless allegation that regarding the torture. My lord, if we go regarding the findings and my lord, the findings of the honorable trial court below, my lord, what has happened, my lord, the trial court below has narrated the facts, but basing on, my lord, what evidence and what is the source that she could prove beyond all reasonable doubt, my lord, I have inflicted torture, both mentally and physically. That finding is missing, my lord. There is no source of that kind of evidence could produce by the, my lord, this present opposite party number 2, my wife, my lord. So that is the, my lord, findings which has been, my lord, relied on, my lord.
You maybe agree with your wife, something different, but you have a child.
I have a child, my lord, and
So how
even, my
much
lord, what is
maintenance
this?
you are giving?
My lord, what the ground
Mother has
really,
to take care of your child.
my lord, I am.
Mother is entitled, child is entitled.
No, my lord, I am not denying that I will not pay to the child or even to my wife, my lord, but the amount which has been paid is excessive and beyond my control, my lord. My lord, what has happened? Apart from this 10,500, my lord, another 6,000 I am paying, my lord. My lord, kindly find that order, my lord, is at page. My lord, may kindly turn to page. My lord, a divorce petition has been filed by my wife, my lord, and against that divorce petition, my lord, under section 24, as usual, my lord, the pendency light maintenance had been claimed. And in that pendency light maintenance, my lord, as an interim, the learned trial court below has also done, my lord, may be pleased to find the operative part is at page 28, my lord. Proceedings, my lord, may kindly turn to page 28, my lord. Proceedings are granted in favor of the petitioner wife. It will meet the ends of justice. Accordingly, OP husband is directed to pay to the petitioner wife an amount of rupees 4,000 only per month for herself and rupees 2,000 only per month for the minor son. That is total rupees 6,000 per month as maintenance pendency light till disposal of the main suit, and another amount of rupees 2,000 only as cost of the proceeding. That cost me lot 2,000 as a one time, my lord, I am ready to pay, but this 6,000 my lord along with rupees 10,500 is my lord very harsh for me, and the amount is a big burden, my lord. And now, my lord, as a teacher, my lord may kindly appreciate, my lord, that as I am earning a rupees 24,000 only, if rupees, my lord, 16,000 is required to be paid. I have, my lord, ailing mother, and two unmarried, my lord, sisters are also, my lord, dependent on me, my lord. But those things has not been considered by both the learned trial court below, my lord. That is the issue, my lord. The real ground reality is that, my lord, the demand of my wife is so excessive.
Is pursuant to this order of the Joint Family Court, are you receiving rupees 6,000, 4,000 for your?
No, Lordship, I have the certified copies, Lordship. Only twice that statement that I have made in paragraph 7, yes, Lordship. Twice he has paid, Lordship, 6,000, 6,000, and in one occasion he paid 4,000. So this is all about, and I have the certified copies also regarding the payment. I have obtained this,
No, my lord,
Lordship.
I am not denying that, my lord, my.
And Lordship, I also have to state that he has the burden. That means the mother of the petitioner here, Lordship, husband, she is a pension holder, family pension holder. And the sister, she is a TET teacher. I also have the evidence of with me, Lordship. I have everything with me. So this type of submission, Lordship, these are not expected, Lordship.
Have you stated in your application regarding this?
Lordship, application I am paying for an interim here, Lordship.
That is.
Yes,
Have you
but when I will rebut, Lordship, this criminal petition, Lordship, I will definitely place these things. Now they have not filed any reply to that, Lordship. This was filed I think
Lord,
2 months
this-
back, Lordship.
My lord, that is correct.
So Lordship, now stating these things without any proof, Lordship. So how this can be justified, Lordship?
My lord, my learned friend, miscase has been, notice has been issued, my lord, on 15/7/2024, my lord. My lord, I have a very limited knowledge regarding, my lord, criminal proceeding, my lord, but I have gone through the provision of section 125, my lord. In section 125, if some person is not complying, my lord, there are provision, and they have already, my lord, filed an execution proceeding also, my lord, and that execution proceeding is going on. Now, whether this criminal petition, this, my lord, interlocutory application is maintainable in the present form or not, that is also an issue, my lord. I am not going on these technical issues, my lord, as there is an order of the learned trial court below, and I am duty bound to comply with the order, my lord, until and unless that order is interfered with by my lordships, my lord. But the only thing, my lord, is that I am with overburden with rupees 16,500, my lord, at the mercy of my lordships, my lord. I want that the amount, can it be reduced, my lord, to certain amount that the amount is likely to be paid, my lord.
Lordship, 16,000, it is not. These are, that means wrongly calculated, Lordship. We are onto these things, 10,500,
No, no,
Lordship.
that is correct.
This is, Lordship,
10,500
we are
is
never been
maintenance, my
this
lord. I am
6,000, Lordship,
I-
because the penalty light proceedings. And this has been given twice, Lordship. I have the certified copy.
No,
And
Lord,
Lordship,
I am-
the execution case that is going on, Lordship. There were occasion, Lordship, the petitioner, that means the husband, he rang the opposite party, that means the wife, Lordship, and he stated that you do whatever you like, I am not going to pay.
These are all baseless.
These
things,
are
my
all
lord. There-
things,
there is a-
Lordship.
These are all, my lord,
These
law is
things,
there.
and
Lord,
what
law
is
will
there,
take its own
Lordship?
course.
It is not a fact that he is that means unemployed. It is admitted by the parties also that
I am
he
not
is
saying
an
that, my
employer.
lord, I am
But
unemployed.
why he is bringing all these things which is not on record, Lordship?
Lord, I am not stating before.
Here
lordship
simply, Lordship,
that
these
I
are
am
social legislation, Lordship, when the petitioner, and I also have stated, yes, I am an educated one, but because of certain condition, I am unable to maintain myself. She is unable to leave her son, because under whose care she will leave her son. Her mother is also an ailing one. She is unable, she has some hearing problem. She has unable to vision problem, Lordship. How it can be?
My lord, may I have a permission to submit a little, my lord, more, my lord. My lord, the recent instruction which we have received, my lord, even the present job has also been terminated from the school by the present petitioner has been terminated. Now, at this moment, my lord, I am jobless. Even then, my lord, my respected senior friend has admitted that I have paid something, my lord. But my lord, may kindly appreciate that as an husband, as an unemployed, my lord. I have to be the, my lord, the source to pay, my lord. That source has also been, my lord, curtailed at this moment, my lord. Now, my lord, if I cannot pay a single penny, my lord, what will be the consequences? I will be put behind the bar, my lord. That will obviously not serve the purpose, my lord. I have a child and, my lord, I have to take care of that child also, my lord. Even my wife has, my lord, debarred me from, my lord, meeting the child also, my lord, at this moment.
Lordship,
That is
there
the
are
situation.
processes also.
No, no,
If
there
he
are-
really wants
My
to,
lord.
there are proceedings also.
Exactly, my lord. There are proceeding also for if somebody is not paying, that proceeding can be, section 125 can be invoked, my lord. But not by way of this miscase here in the instant criminal petition, my lord. Process is applicable for all, my lord, not only for me.
Kindly go through the miscase, why this has been filed.
I have gone through. Ultimately, they'll. No. Yeah.
And one.
One. না সেইটো কাৰণে petition মাৰিব লাগিব।
Whatever amount I have received till date, Lordship, this is there in my petition. And in the execution case, Lordship, whatever is there, because as there was, they have produced the copy of the petition before the court, the certified copy where the order reflects Lordship. That's why the court did not interfere even, Lordship. And out of 10,500, Lordship, only 6,000, 5,000 has been paid.
Order. One. On your phone.
Mr. Bhuya,
My lord.
paragraph 18.
Of my petition, my lord. My lord, that be submitted immediately the certified copy of the order dated is had started paying maintenance as per the court's order, despite the petitioner used to receive rupees 10,000 per month as salary from Progressive School, Badarpur. That this is, my lord, regarding the maintenance pendency light statement we have made, my lord.
That's right.
My lord.
Now come to page 22.
My lord. 22, my lord.
Paragraph 2 of your affidavit.
My lord. that the statement made in this affidavit in paragraph, my lord, unfortunately, we have left our office copy blank, my lord. That
Paragraph 18 is from records.
records, my lord.
So you kindly show us
My lord.
on the next that you are paying regularly after in terms of this.
No, my lord,
particular
on till
paragraph. We will
14,
not say anything else.
14/12/22, my lord, the last payment which we have made, my lord.
You are saying you are paying. Right?
Till,
We have to, it's a continuous thing.
my lord.
Then you should have made a statement and we have paid and we have stopped paying. There are two versions, right, Mr. Via?
No, that is
Let the-
correct, my
let
lord. That is,
The appellant, the petitioner show
my lord.
that he has been paying on the next date.
No, my lord,
No,
whatever I have paid, my lord, my learned
That will
friend
not
has
be enough.
already brought on record, my lord. I am not denying that issues, my lord.
Then in that case,
Lord-
Mr. Via face the consequences.
No, my lord, my lord, I have to,
If you
my
are,
lord,
see, you are, on one hand, you are saying,
my lord.
you are challenging the order of the family court because at the same time, you are also paying as a dependent like amount of
My lord.
6,000. And it has become burden on you.
That is correct.
10,000 something you have to pay.
No, my lord, as a whole, my lord, what my case,
10,500 plus 6,000, it has become a huge amount. So it is not
16,500, my lord,
possible. It is
because,
not possible for your.
no, my lord, what my
Court would
subject,
have- Court would have considered,
my lord,
court would have considered it.
if I am
If-
continuously paying, my lord.
Something is there, but when the petitioner here is playing with the orders of the court.
No, my lord, there is, my lord, I am,
And you know that in the 125 proceeding, it's.
my
very
lord,
clear.
I am, what I am respectfully back to submit, my lord, there is no question of playing with the honorable,
Mr. See,
my
in
lord,
these cases, you know,
my
it's
lord.
difficult for the, sometimes, as you have seen, even the judgments of the apex court,
There is very, for the husband, my lord, I know, my lord, the scope of, my lord, getting the relief is very limited,
there
my
was
lord.
an interesting case
My lord,
earlier.
my lord.
uh,
My lord, all laws are made for wives only, my lord.
No, it has to be.
My
That is
lord,
what the apex court, it was brought to the
My
notice of the apex. It was an old case where the honorable apex court considered the fact that an able-bodied person,
my lord.
you are saying, just like you saying that you have no job, nothing.
Yes, my lord.
Court, the apex court did not consider that as very clearly say it will be his duty to maintain his wife, maintain his children as per his own standard. The
My lord.
standard he is living, same standard he has to provide to his.
His wife
That's
also.
right. And in that particular case, Honorable Apex Court said it was the hours before the Honorable Apex Court that he was jobless.
Subsequently jobless, my lord.
Whatever.
My lord.
It is
My
the
lord, I
duty
have,
of the
my lord, the same
So,
judgment, my lord.
Mr. Bhuya,
My lord, my lord,
we have heard you.
my
We
lord,
are not passing any order on today.
my lord.
Today is 1st of August. We are fixing this matter on 9th of August.
My lord.
That's it. That's up to you, not to Mr. Bhuya, petitioner. We'll pass the order
My
on
lord.
that day.
No.
Ask your client.
I have all the certified copies, Lordship, the payment and
No,
all
my
this,
lord, the
Lordship.
payment part, my lord, we are not
Till
denying,
date,
my lord.
21,000 has been paid, Lordship, this is there.
My lord.
The consequences.
Consequences, my lord, I am, my lord,
Whatever.
And in execution, they have shown the High Court, this means filing of the High
No,
Court
my lord,
case,
There
Lordship.
is no, till date it has not.
Yes, Lordship, it is reflected in the order as well,
my lord,
Lordship.
we have only said that there is a petition pending, but there is
Mr.
no,
Bhuya,
my lord, my lord.
will not say anything else.
My
We are
lord.
fixing the matter on 9th. You know
On-
the consequence. Heard Mr. Your Bhuya counsel hearing for the. And I'm land council. Both with the ILP. Placed on 9th. And on the same date. The petitioner shall apprise the court the amount of maintenance that he had paid to the respondent number 2 and their minor child pursuant to the judgment dated 26/09/2023 passed by Learned Family Court, Kachar at Silchar in FC Indicated Criminal CRL, case number 37 of the 2021, as well as the order passed by Learned Family Court, Silchar, dated 14/12/2022. In action civil, miss case number 7/2021, arising out of FC civil case number 168 and Leicester Court. Hard law court, miss and a butcher.
Obliged, my lord.
Deeply obliged, my lord.
To take back Ms. Patanjali, we will consider in next date.
Lordship. Deeply obliged.
Zoya. If not, long one. Hard Mr. S. Nawal. Land Council for the action. And I must add the hunt. Appearing for the respondent. Sorry, negative. Also heard Mr. P.K. Rajchaudhary, Land Council for the respondent number 1. And I must add the hunt and additional purpose. From for the respondent.
If my lord allows, one thing I've noticed in the dismissal order of the revision, their stay order is not vacated. Otherwise it goes, but then specifically
One, that is the law. Once the petition goes.
everything
it is
goes.
Also not mentioned.
But normally lordship does that.
Sometimes it is written, but that is
Written.
why in that particular case, the judgment honorable apex could have clearly specified. If it is not there, if the case is not there, when the
Then
question of,
it
that's why
automatically
the
goes.
honorable apex should clarify everything. Okay? In fact, just like you have pointed out here, in that particular case, the honorable apex court, it was asked by a very senior counsel. It was that it was not vacated. They still continued. So it was in that circumstances, in fact, there was a particular remark continued in that judgment. If you read it.
Oh, I've not gone through that judgment. I will.
Said no. Goes, everything goes.
It goes. Not.
Initially, they doesn't wanted to pay, so that is the reason in that particular matter.
Acha.
So they continued their practice. Being agree with an order needed 30/07/2021 for the Learned Executive Magistrate for the Sampadev Nagar. In MR case number 193/2020, comma, under section 107/145 CRPC, whereby the Learned Executive Magistrate on perusal of the complaint petition preferred by the respondent number 1 and on perusal of the police report as well as the letter issued by the circle officer, the Boca Revenue Circle, dated 14/07/2021, that was addressed to the officer in charge of the other police station regarding deputation of police personnel in cultivation of land of at Terapur village as per schedule of land specified in the said order comma, directed the officer in charge of Morazar Police Station to depute police personnel in that area during cultivation only by the petitioner of said MR case number 193 of 2020. I, the respondent number 1, carry on being satisfied that there are also that there was an apprehension or breach of peace and tranquility. And as such, said executive magistrate drawn a proceeding under section 107 of 145 CRPC, directing both the parties to appear before the said court on the next date, fixing it on 19/01/2021. In the said MR case number 193 of 2020 preferred by the respondent number 1 before the executive magistrate Jai Venkateswara Nagar. The present petitioners were made the respondents. It is submitted on behalf of the petitioner by Mr. Nawaz Learned Counsel that he doesn't have any objection to appear before the magistrate, and also against drawing up of proceeding under section 107 of 145 CRPC by the learned executive magistrate by the said order dated 30/07/2021 noted report. But agree only to the extent that that the said executive magistrate allow the respondent number 1 petitioner of the MR case number such and such to cultivate the said land next. Both the petitioner and the respondent number 1 placed before the court that against the said order dated 30/07/2021, the present petitioners passed by under executive magistrate. The present petitioners preferred a criminal revision. Preferred a revision petition being criminal revision case number 6 H of 2021 under section 397 of 399 CRPC before the learned session judge Ojai. While issuing notice, the learned session judge by order is 07/08/2021 passed in said criminal revision case number 6 of 2020. Issuing notice admitting by order state the said order of the learned executive magistrate dated 30/07/2021 passed in a market. Later, after hearing both the petitioners That's number one. And then comment. London Session Judge Ojai by judgment dated 28/11/2023. Past inside criminal division number 06 within bracket H 2021. Dismissed the same by orderly dismissed the said criminal division number 06 within bracket H that was preferred by the being without merit and and allowing the petitioners to approach the trial court to redress grievances, its grievance if so advised and permitted by law, comma, sending back the records of safe MR numbers such and such to the court of London executive magistrate. Put a copy of the status. Next. The petitioners in this criminal petition have not only challenged the order to the 30/07/2021 caused by London executive magistrate Jose Sankar in MR case number 193, but also the order dated as challenged both the order to the 30 as well as the order dated 28/11/2023 caused by London sessions of in criminal division number 06820. Notice in this criminal petition was issued by the court, no, by order dated 06/03/2024. And by the said order dated 06/03/2024 also call for the records of MR case number, scan copy of the records of MR case number 193 of 2024 from the court of the London executive. Mr. Nawaz, London counsel for the petition, Mr. Roy Chaudhary, London counsel for the rest number 1, and MS Jahan, London additional prosecutor, appearing for the state prosecutor, placed the various provisions of section 107 and 145 SPC. And also to comment here, to place their case. Mr. Nawaz, learned counsel representing the petitioners as noted above. Is agreed. Committed that the petitioners are agreed only to the limited extent allowing the respondent number one. The petitioner applicant of, no, like applicant of said, applicant first party of said MR case number 193 of 2000. Allowing the petitioner to cultivate the land in question. And they agreed that if the said first party slash petitioner respond number one or eight is not allowed to cultivate the said land till disposal of said MR case number such and such, the proceeding under section 30. Doesn't have any such objection in the land between the ministry and the state. Mr. Pickett was Chaudhary Learned Counsel appearing for the respondent number one slash first party of said MR case number. Committed that as the order dated 30/07/2021 was passed way back 4 years, way back like 4 years ago. And the said cultivation means only for a year. Therefore, there is no merit with the prayer of the petitioners in challenging this order at the 30/07/2021 passed by Land Executive Minister for the Assam number. We have seen that the order that while issuing the order that is 30/07/2021 passed by Land Executive Magistrate in such and such. Consider the complaint petition of the respondent. The letter of the circle officer, the Boca Revenue Circle, dated 14/07/2021, addressing it to the officer in charge of Moradar Police Station. And the report of the officer in charge of Moradar Police Station that was talked about. Okay. We'll complete it. We have said that on 29th will appear, right?
So your lordship will continue at 2
If the other matters are doesn't take, we'll do it. Otherwise,
in the chamber.
on that ground.
Yes, your lordship.
Now the counsel for the petitioner is here.
Yes, your lordship. A short date may be fixed on it.
Sorry. Let us see. We'll proceed to certain.
Am I, my lord, admitted, sorry, permitted lordship?
Just.
Any slum so
Take your seat.
Great.
the evidence, the doctor who conducted the postmortem was asked. There are few injuries on his elbow joint and knee. And all aberration, he said all aberration means prior to 2-3 days prior to the incident, prior to his death. Now, the opinion is because of cardiac arrest.
My lord, apart from that,
And then he result of cardiomyopathy. Wife, of course, then during his cross, the concerned doctor who conducted the postmortem said that that such kind of injuries may occur by falling on hard metal. And the injuries that he sustained is not sufficient in ordinary course of nature to cause death. That is which.
302 lordship does not come now.
This is.
Now, my lord, other section.
Then we just see there. But we have seen the father of the deceased during his cross clearly stated that more Laura Hartor Hukasil.
That may be lordship, but the
Now,
injury lordship. I'm
then PW7, another doctor who was called to the residence of the deceased or the informant. He stated that the victim was suffering badly from diarrhea.
how is it possible? But one said
He
my
was the village
cardiac arrest,
doctor.
lordship.
He was the village doctor.
He's also my lord, the doctor of my lord, Lopata civil service, my lord.
True,
civil
that
hospital, lord.
the evidence of the informant said that did not took him to other place, but called the village doctor. A doctor may be residing in that village and might be serving in the Borpeta Civil Hospital.
Immediately, lordship,
So on his advice, it is the same doctor, because he being from the same village, these are the evidence that that is why it is clear that only on the advice of this doctor, the deceased was taken to the hospital, but on the way he expired.
yeah, doctor from hospital, my lord says it is due to cardiac
It is
arrest.
there
lordship.
some.
My
Just
lord,
a minute.
diarrhea and cardiac arrest are two different things, lordship.
Just
My
a
lord,
minute. He expired because of cardiac arrest. Father said he was suffering, he was an heart patient.
Other doctor says he was, my lord, suffering from diarrhea, lordship. So this is,
There is a reason behind that.
I'm submitting lordship, apart from that, law, that part, lord, 302 lordship. My lord, injuries are there, lordship. It is not denied, lordship. Injuries are not denied, lordship, then my lord, other section comes, lord, 325 comes. Now accused, my lord, offender cannot be, my lord, unpunished, lordship. Other provisions, other sections could have been imposed. SARS could have been, my lord, converted to 325 lordship. Eyewitness is very much clear, lordship. Doctors finding that there was injuries based on like this one. My lord, it cannot, it is not denied by other during cross-examination.
Ms. Jahan, have you gone through the records? But any Mumbai, any minute?
Not there.
But thing is this, the concerned autopsy doctor
Lordship.
clearly stated that the injury sustained by the deceased cannot be a cause for his death.
Cannot be the cause for his death.
And there was no injuries on the vital parts of the body of the deceased.
Ah.
And then deceased died because of the heart disease. And the report is that he died because of cardiac arrest.
Hmm.
As a result of myopathy.
As a result of,
Myopathy.
oh, myopathy. So it seems it's a natural death,
And
not
then
because of the
father of the
injuries.
deceased,
Huh,
in his cross clearly stated that my son was suffering from heart disease.
acha.
That was his state. The one of the doctor who used to stay in that village, who is also is work in the
Hmm.
Barpeta Civil Hospital. In the morning, he was called for
Hmm.
after the incident. He came and saw during his evidence. He said he was suffering from diarrhea
Acha.
because he had a very fragile body.
Hmm.
So he was suffering from diarrhea. He should be immediately taken to
Morning of the occurrence.
next day.
Hmm.
Morning next, because incident occurred at night.
Hmm.
And then next day morning, doctor came and saw him. He was advised to take to Barpeta Civil Hospital. Then on that night, next day night, there was a village meeting with regard to the incident. It was an allegation that the deceased stolen a pump
Hmm.
from the house of the
Hmm.
accused persons, alleged accused persons. So they came and beaten up
Hmm.
the deceased. During such, he sustained injuries in his elbow or his knees, anything like that. It is clear that there was any such lathis or blows or something. Only he
Fist,
was
fist blows and all.
blows and manhandled basically. But he sustained injury at his leg and elbow. There was no doubt. Now these are the incidents, and then when the postmortem doctor said that there was no
Hmm.
vital injury or there is no such injury in the vital parts of the body, then the deceased died because of his heart disease.
Hmm.
And then father is saying he was suffering from heart disease.
Hmm.
The doctor who came to their residence saw him. He said that he was suffering from, because he was acquainted with that doctor.
Hmm.
So doctor said he was suffering from
Diarrhea.
diarrhea, so he should go. He sent to the Barpeta Civil Hospital. Considering those materials, the Learned Trial Court did not acquitted the accused persons.
Huh.
That's all. That's against which it have come.
Oh, against acquittal he has come.
Why?
He was already very weak, and these injuries, whatever superficial, that might have aggravated. That can be a
That
situation.
may be a cause.
But PM report says that heart disease. So may not be a homicidal as such.
No, that is not there. What is saying that it should be because he was physically assaulted
Hmm.
by his, and he died 2 days later.
2 days later of the incident. But in these circumstances, proving homicide is difficult.
So nothing around even 304 to convert it 304. How do you say it? Because it is a case that there is allegation that he has stolen the
Hmm.
day came manhunt.
Manhandle.
That's all.
It cannot be a culpable homicide also.
That's why nothing. The ingredients of 304 will also not be there.
Come. At best 325, 323. Not
Because
even.
of his evidence of the doctor, the two doctors particularly,
Hmm.
the father,
Hmm.
the trial court has acquitted the accused.
Hmm.
That's the reason. But for the petitioner here, or the appellant here, because of this keeping the wife,
Hmm.
it is a fact that these accused persons had manhandled.
Yes,
That
manhandle, that's a fact. But whether it
It is
resulted
there,
in death.
Hatere marise,
Hmm.
that is
Hmm.
necessarily.
Your lordship.
Sometimes it may happen. Blow may
Ah.
be
Hit
there
those
in the
parts
vital part. But the
very,
evidence of the autopsy doctor is very clear. I did not find injury on the vital part of the deceased.
he being a
Some kind
heart,
of rupture, some
some
vital parts of the
ruptures.
body. Definitely that will indicate something.
Mm.
But this autopsy doctor has clearly stated I did not find injury on the vital parts of the body of the deceased.
Internal rupture and also is
Nothing
also
is
not there.
That is why
Mm.
there was no bleeding, nothing.
Mm.
Only injury was in his elbow and the two knees.
So we cannot presume that those injuries had aggravated and then that we cannot presume in a criminal
Though in
case.
subsequent stage after the date, maybe they should have, they did not lodge any affair immediately. He came after the date of the deceased.
2 days after.
Incident happened on 18, 19, full day of 19, full day of 20th.
Explanation is there, Lordship.
Explanation might be there.
They are busy in treatment and all.
No, no.
Perhaps.
Compromise was going.
Oh,
Yes, there was
compromise.
bail, my lord, in the meeting.
There was a village, there was a
Yes.
Village meeting.
village meeting was there.
That is why affair was not lost. When he becomes serious,
Manhandle is there. But thing is this, how will you bring it
It
here?
happens in
Because that
villages.
when it is clearly mentioned by the
And your lordship,
father of the deceased that you are suffering from heart disease, the autopsy doctor said he died of cardiac arrest. And then the injury is not sufficient for a person to die. The cause of death cannot be for those injuries. There was no such fatal injury in the injuries or any fatal injuries in the vital part of the body. When these were available, no doubt medical.
The
But,
lordship can convert it to 323 and 1 year punishment, I think. Or because manhandle, that evidence is there.
regarding manhandling also, your lordship, the doctor has stated, your lordship, in his evidence that those abrasions may be caused due to falling also.
No, that may be.
No,
my
no,
lord.
that
It is
is
injury, it is not conclusive, Lordship.
And regarding the eyewitnesses, your lordship, everyone has stated that they have been the eyewitness in this case. But in the cross-examination of the IO, which submitted the charge sheet, he has later stated that those were not the eyewitnesses. They were. It came to know from their cross-examinations that none of them, except the wife and Haruk Khan, has seen the occurrence.
So
They have
those
heard it from
witnesses are
the family
sufficient.
members.
Those witnesses are sufficient. Wife and Haruk Khan,
Witnesses
they are
only
eyewitnesses,
what we
clear evidence. And the medical officer, my lord, has also corroborated the injuries. That injuries, my lord, have not
No,
been
in fact,
denied.
the IO from the case diary.
I ought to have been, my lord, declared hostile, Lordship, in this case.
IO hostile?
Yes,
No, he has stated what.
IO
that's
का
it.
क्या hostile होगा?
against.
No, he has not stated what is there. He has stated.
Hostile will come when you have two different versions before the police and before the court. IO तो कहने का hostile होगा?
You would have against the people.
FIR against.
No,
See, the person who investigated the
Where the
matter,
record.
Lordship.
he deposed.
Yes, sir.
And the person who submitted the search sheet after the investigation, because the person concerned was transferred, he was also
Yes, sir.
prosecution witness.
In favor of accused.
Yes.
So, not in favor of it, in favor of what
Something
they
was
say,
there,
just,
Lord.
just listen.
Hmm.
যোৱা 20/9/2005 ইংৰাজী তাৰিখে হাউলি আৰক্ষী চকীত ভাৰপ্ৰাপ্ত বিষয়া হিচাপে কাম কৰি আছিলো। উক্ত দিনা ৰাতি 9টামান বজাত হাজিপাৰা নিবাসী ডালু খানৰ পৰিবাৰ আলিমুন্নেছা এখন লিখিত এজাহাৰ হাউলি আৰক্ষী চকীত দিয়ে। এজাহাৰকাৰীক এজাহাৰ ৰিলিজ কৰা যোৱা 18/9/2005 ইংৰাজী তাৰিখে ৰবিবাৰে ৰাতি অনুমান 10টামান বজাত আছামী গাজিবুৰ ৰহমান পিতা মৃত সাচেন চাচ আৰু তাহাৰুল ইছলাম পিতা সাচেন চাচ, they have all the accused persons, সকলোৰে ঘৰ হাজিপৰা তেওঁৰ ঘৰত অনাধিকাৰ প্ৰৱেশ কৰি তেওঁৰ স্বামী ডালু খানক হাজিবুৰ মিয়া কল চুৰি কৰা বুলি হাতেৰে শৰীৰৰ নানা ঠাইত মাৰপিট কৰে। This is the FIR talking about. And নবীবৰ আৰু বাক্য কোৰখানে মোক কেছ কৰিব নালাগে বুলি স্বামীৰ চিকিৎসাৰ বাবে 200 টকা দিয়ে। মই এজাহাৰখন পাই এজাহাৰ কন্টেন্টছখিনি জিডি এন্ট্ৰি কৰি জিডি নাম্বাৰ সাচেন চাচ কৰি ডেটা ডিমাণ্ড কৰি এজাহাৰখন বৰপেটা থানাত ৰেজিষ্ট্ৰেশ্যন কৰাৰ বাবে পঠিয়াওঁ আৰু গোচৰৰ তদন্ত মই নিজে লওঁ। মই এজাহাৰকাৰীৰ জবানবন্দী থানাত লওঁ আৰু তেওঁৰ জবানবন্দীৰ পৰা জানিব পাৰো যে স্বামীৰ মৃতদেহ তেখেতৰ ঘৰত আছে। তেওঁৰ ঘৰত কোনো পোহৰৰ অৱস্থা নথকাত মৃতদেহ থানাত অনা হয় আৰু পিছদিনা মৃতদেহৰ চোৰঠাল কৰা হয়। ইনকুৱেষ্ট ৰিপৰ্ট এক্সিবিট 2 চিগনেচাৰ্ছ এণ্ড আদাৰ্ছ টকিং এবাউট। মই ইনকুৱেষ্ট কৰাৰ পিছত মৃতদেহ বৰপেটা চিভিল হস্পিটেলত পষ্টমৰ্টেম কৰাবৰ বাবে পঠিয়াওঁ। মই পিছত বৰপেটা চিভিল হস্পিটেলৰ পৰা পষ্টমৰ্টেম ৰিপৰ্ট সংগ্ৰহ কৰোঁ। বাকী সাক্ষীবিলাকৰ জবানবন্দী ৰেকৰ্ড কৰা আৰু ঘটনাস্থলীৰ স্কেটছ মেপ ড্ৰ কৰা। মই বাকী বাদী হোৱাত বদলি হোৱাত মই গোচৰৰ ডায়েৰী বৰপেটা থানাৰ OC মহোদয়ক চমজাই দিওঁ আৰু মোৰ পৰৱৰ্তী বিষয়া সুবল চন্দ্ৰ তালুকদাৰৰ অভিযোগ পত্ৰ দাখিল কৰে। Then the FIR and the charge. Then cross. এজাহাৰখনৰ ঘটনাৰ তাৰিখ 18/9/2005 বুলি উল্লেখ কৰা আছে আৰু এজাহাৰখন 20/9/2005 ইংৰাজী তাৰিখে দাখিল কৰা হৈছে। এজাহাৰ দিয়াত দুদিন কিয় পলম হ'ল এজাহাৰত উল্লেখ কৰা নাই। Exhibit 2 inquest report, carbon copy and signature content there also carbon copy. PW2 হালিমেন নেছা মোৰ আগত জবানবন্দী দিওঁতে কোৱা নাছিল যে ডিনাইট মুমতাজ আৰু নুৰ নেছাৰ আমাৰ ঘৰত দৰ্জা ভাঙি সোমাই আৰু কয় যে কমপ্লেইন লেংগুৱেজ অজ ইউজ আছামী জহুদিলে কয় যে তেতিয়া স্বামীক কিয় কল চুৰি কটাৰ অনা নাই। তেতিয়া আছামীয়ে পুনৰ বেয়া গালি পাৰে আৰু মোৰ স্বামীক আছামীজনে বুকু মাৰে। মই হাতে ভৰিত ধৰি স্বামীক মাৰিবলৈ মনা কৰোঁ। তেতিয়াও আছামীজনে মাৰে। মই বাধা দিয়াত মোক আছামীজনে মাৰে। মই তেতিয়া চিঞৰ বাখৰ কৰোঁ। মোৰ হাল্লা শুনি মোৰ মামাহঁতৰ ঘৰখন আহে। তেতিয়া আছামীগণ গুচি
One thing I would like to point out, the complainant has also filed a FIR against the LS second wife, my lord. In that case, the second wife has been acquitted, my lord. One.
Yes, Ms. Jahan, you have to go through the evidence.
Lordship. ऐसा नहीं किया जाना।
See, 494, as you know,
हाँ।
the second marriage has to be somebody else.
Oh.
And gave her son to him, the accused, appellant here, for adoption.
Oh.
And he adopted his son.
Hmm. So in that case,
There was no
494.
marriage. Now, how the marriage, whether who, because seeing some lady with the accused doesn't mean that there is a marriage.
They have married.
Marriage has to be there.
Yes, yes.
Where is that marriage? Now, two persons,
Hmm.
maybe impersonated or something, there is nothing like that.
Hmm.
Two persons got married,
Hmm.
according to the informant.
Hmm.
They got married in some particular temple.
Hmm.
And the pujari of the temple has given a certificate to them.
Hmm.
Those documents have been seized.
Hmm.
Because the name of the persons are different.
Oh.
And the pujari did not identify that these two are the persons whom I have given marriage in the temple.
Hmm. They might have changed their name, but Pujari has to recognize.
Pujari have to identify it. Pujari did
Identify.
not identify it.
Hmm. In that case, of course, their identity is not proved.
Again, then, of course, the names are different. Let us assume that they have given a different.
Hmm.
That unless
Hmm.
the pujari identify that the witnesses whose names are there in that marriage certificate
Hmm.
identified.
That they are these persons. So they cannot, there has to be other evidence then.
There is no. Apart
Hmm.
from the Pujari, there is no evidence.
No other evidence.
And my
Let it come up day after tomorrow. I will go through.
Not on Friday.
Acha.
Tomorrow is Friday.
Oh, tomorrow is
Day after
Monday.
Saturday, Tuesday,
On Monday or Tuesday?
Tuesday.
Doctor.
One thing I would like to point out, the second wife, alleged to be second wife, against that also a case was registered, but she was subsequently acquitted. And,
Case was registered under 494.
But this is against the husband
Hmm.
by his first wife.
Complaint is same, my lord, first wife. He has also filed a separate case against the alleged second wife.
Hmm.
Now, complaint is same.
Yes. Because bigamy lies against
Bhupennath.
both. And there is no appeal file in this case.
He will able to know because he is appearing for the complaint.
Hmm. Here also she could not place any evidence to show the existence of the second marriage. And there was a delay of 5 years.
That was not the ground.
The Pujari, she could not.
Whether the rituals were performed.
Ritual, so.
Out of those 5 witnesses in this case that
Mm.
you have just read, 2 of them were witnesses in this.
Acha. The uncle, Padmavati Devi, yes.
Amala Devi, they were there.
Mm.
Doyle Nath, I think. Keshav Nath.
Mm. Madan Kumar Roy. Padmavati also, Rishabh Nath also, Madan Kumar Roy neither.
Keshav Nath is one of the witnesses.
Mm.
Yes, such a good name.
HK Nath.
Counsel for the petitioner.
Wait a minute. Side of it.
Rahan, additional party, opposite party number. What's your name?
S. Bulwa.
S.
Bulwa. On behalf of Shekhar. On behalf of Shekhar.
Counsel for the opposition.
এখন কার? তোমার? ও, তোমার এখন?
Hardin part. Let's not. 6.
Instead of 6, can it be on?
Let it be on 6.
Well-
These matters, why do you
Small matter.
Douglas.
go to the record?
Rajip is writing. Obla.